Thank you. Pleasure to be back here, and we want to make sure we stay on schedule. Deborah Regan from the State Bar is here, and I want to make sure we do things by the book. So it's always a good idea. So we just heard from Professor Chemerinsky about the importance of state constitutional law, and he mentioned the leading article by Justice William Brennan from New Jersey in 1977, where surprisingly, because he was the justice who had been so responsible for the creation of individual rights under the Warren Court and continuing, talked about the importance of state law and state constitutional law. It remains to this day one of the most highly cited law review articles of all time. I guess I had not really put two and two together, that with what's been happening with especially the last couple of weeks, that it's not surprising that all of us are still thinking and looking, maybe turning back more than we have to think about state constitutions. There's a new book out by a judge on the Sixth Circuit, Jeffrey Sutton, which is all about 51 imperfect solutions. And I just wanted to sort of quote something there. He actually starts with this sort of strange analogy, but being from Duke, it made sense to me about college basketball. So imagine it's the Final Four. This is the only thing I didn't agree with. He had Kentucky playing Kansas in the Final Four, and it should have been Duke, but that's okay. Game's tied. Last second, somebody goes for the shot and gets fouled, and they would have 2 free throws. If you make either one of them, you win the game. And he says, what would it be if the coach said, just take the first one and not take the second shot? It would be crazy. And in fact, what Judge Sutton says is that's kind of what we need to think about with constitutional law. You have your first shot with the federal Constitution, but you have a second shot with the state Constitution. And why would anyone pass up that second shot that could win the game? And I think it's really intriguing to continue to think, as we will all day, about the possible uniqueness, the distinctiveness of state constitutional law. And here's a quote from the book here. Does anyone doubt that Wyoming Supreme Court might look at property rights and the Takings Clause differently than the New York Court of Appeals? And you guys get a plug here. Or that the Alaska Supreme Court might look at privacy issues differently than other states, or for that matter, the Supreme Court. And so as we think today about the Alaska Constitution, we very much wanted to present a comparative perspective and to try to understand the similarities and differences that are at the very essence of the Alaska Supreme Court. And we are so pleased that our two panelists are here because they are the experts on state constitutions. Both come from Rutgers. Alan Tarr is a professor emeritus and was the founder and director of the Center for State Constitutional Studies at Rutgers University in Camden. And then Robert Williams is also an expert on state constitutional law and the current director for the center, authoring a book, The Law of American State Constitutions. So these are the folks who, if you look at their resumes, have published articles and given talks around the country and are the leading experts, I think, in the entire country on the specialness of state constitutional law. It's a great pleasure to have you here, and thank you so much for coming, and the floor is yours.
Thank you. Thank you for that kind introduction. It's really a pleasure to be here, and I want to thank the organizers of the event for bringing me from balmy New Jersey to balmy Alaska. I did not know, however, that I would have the misfortune of having to follow Professor, our keynote speaker here. I suggested to Bob Williams that he go ahead of me. I'm not sure even that would be a really good thing. The other thing I must have to say is that I'm here somewhat under false pretenses in that I'm not a lawyer. I am a political scientist, and my focus tends to be less on constitutional law, that is to say the decisions of various courts, and more on constitutional design, how we get the sort of constitutions we do, and how they've changed over time. And also, of course, this is my first trip to Alaska, and so I cannot claim to have local knowledge. So what you immediately do in these sort of circumstances is you shift the focus from going deeply into Alaska constitutionalism to looking at the Alaska Constitution in a broader context of other constitutions, state constitutions, both to show what's distinctive about the Alaska experience and what is more typical about that experience. So that's the focus of my talk today. I think one way to begin is by thinking about the political circumstances of the drafting of the Alaska Constitution. The delegates to the convention had to address themselves to several audiences simultaneously. First, the Constitution had to address itself to Congress, which would vote on statehood. As Robert Atwood, who was a leading member of the Alaska Statehood Committee, put it, the document you write will be, can, and should be a compelling new argument for statehood itself. Congress would judge the Constitution and would judge the state on the basis of the Constitution it put forth, and this had an effect on the way the Constitution was drafted. They did not want to seem idiosyncratic. They did not want to depart too much from what was the prevailing constitutional wisdom of the time. So, for example, during the convention, delegates debated whether to establish a unicameral or a bicameral legislature. And Delegate Dora Sweeney cautioned that Congress might not approve the Constitution if it had a unicameral legislature. And that argument won the day. We ended up with a bicameral legislature. The convention also thought about what sorts of issues might pose problems for Congress. And so the delegates in some instances deferred issues such as native land claims from being addressed during the Constitutional Convention for another day. The second audience that the delegates had to address themselves to was, of course, the residents of the state who had to ratify the Constitution. This again cautioned against provisions that might be perceived as partisan or might be perceived as controversial. It also led the delegates halfway through the convention to have a recess, a 15-day recess, during which the delegates went out to various public meetings throughout the state to get popular input as to their work. A sort of conferring halfway, and this again affected the sort of constitution that was adopted. Third, the Constitution had to serve to produce a government that really worked. And this was a concern given the deficiencies of the territorial government. If the Constitution did not immediately serve the purpose for which it was created, it would be changed. And the work of the delegates would be lost. And this was important because the fourth audience that the delegates were concerned with was posterity. They hoped the Constitution would earn them the gratitude and respect of Alaska's future generations. This is not at all unusual. Convention delegates typically have a broader perspective, a more long-term perspective than, say, do legislators. And they seek to rise above narrow partisan concerns. In Alaska in particular, during the territorial period, fierce partisan conflict within the territorial legislature. But in the Constitutional Convention, no such conflict, no such divisions along partisan lines. Let me approach the Constitution from a somewhat different angle, situating it in time and place. The Alaska Constitution is, of course, the state's first and only constitution. And it's really hard to overestimate the importance of that factor. When a state is typically revising its constitution, the constitution that was in place becomes the template upon which you work. The state retains provisions which are non-controversial, and beyond that, if you have a constitution in place, interests have arisen based on the previous constitution. Usually in a state constitutional convention, when the revision of a constitution is taking place, the division is between those who wish to maintain the status quo and those who wish to change it. In the Alaska situation, of course, there's no status quo to be defended. And precisely because of that, the delegates at the convention were able to think more broadly and more deeply. They weren't just tinkering, they were creating something quite new. Still, Alaska did have a constitutional history of a sort, that is to say, it had a territorial government. And its experience, its unhappy experience with that government, also influenced the Constitutional Convention. To take but one example, the Alaska delegates believed that a major problem with the territorial government had been its weak and fragmented executive. And so they created one of the nation's most powerful governorships. The Alaska Constitution is also preeminently a Western Constitution. Despite the distance from the lower 48, Alaska shares many characteristics and challenges with other Western states. One major concern for Western states, particularly as they attain statehood, has been the power of out-of-state economic forces. Western states typically exported primary products. They lacked the resources necessary for their own development, and they were dependent on distant investors and an equally distant federal government for their prosperity. Thus, when the Western states drafted their initial constitutions or revised earlier ones, they sought to tame the economic and political power of large corporations, such as mining and railroad corporations. And even as they sought to limit or circumscribe corporate power, they tried not to impose overly burdensome restrictions because the corporations were nonetheless essential to economic development. Put simply, the Western states, and Alaska among them, were trying to reap the rewards and avoid the pitfalls of economic growth. The Alaska Constitution very specifically recognizes the importance of economic forces outside the borders of the state. Article 8 forthrightly commands the state, or commits the state, to economic development. Let me quote, "It's the policy of the state to encourage the settlement of its land and the development of its resources by making them available for maximum use." But it also insists that such development should benefit all residents of the state. In seeking the rewards of economic development without its pitfalls, the Alaska Constitution does depart from other Western constitutions in some respects. Most obviously, whereas earlier Western constitutions eliminated legal doctrines that disadvantaged workers, the development of tort law and development of federal labor law during the intervening years had changed the legal landscape. So those sorts of provisions that you find in other Western constitutions do not appear in the Alaska Constitution. Finally, the Alaska Constitution is very much a mid-20th century constitution, and this is reflected both in its form and in its content. To show why, let me focus on two key features of state constitutional development: constitutional borrowing and the progressive understanding of constitutional design. First, borrowing. Throughout American history, state constitution makers have looked beyond their own borders and borrowed from other state constitutions. When students do it, we call it plagiarism. When the conventions do it, we call it statesmanship. Common problems, the similarity of the task of constitutional design, and an attachment to constitutional arrangements in the states from which some delegates may have emigrated, all contribute to this borrowing. Developments during the 20th century have further contributed to such borrowing. Among the most important of these was the increased use of so-called constitutional commissions, bodies which have the time, the resources, and the staff to study the constitutions in other states and to provide information about that to the delegates. In Alaska, for example, the Statehood Committee served this purpose, aided by outside experts, including two from my own state of New Jersey, who brought advice as to the task of constitution making. This takes us to constitution making as a progressive enterprise. Although the state's willingness to consult the constitutions of other states may not have changed, where they look and why they look has changed. Since at least the mid-19th century, state constitution makers have assumed that framing a good constitution requires the constant readjustment of past practices and past institutional arrangements in light of progress. They have also believed that the experience of self-government since the 18th century has expanded knowledge about good constitutional design so that later states are better able than earlier states or the federal founders to develop good constitutions. So this affects where they look for guidance. The interest in modern constitutional design means you look at the most recent states or the states that are most like you, rather than, say, looking back to Philadelphia in 1787. This reliance on modern constitutionalism, this borrowing, looking at the most recent, continues, but the understanding of what a good constitution is changes over time. If you look at the late 19th century, the big concern at that time, perhaps appropriately, was legislatures that you didn't trust. And so the tendency during that period was to create very long, detailed constitutions to circumscribe the powers of legislatures, and if you knew what sort of policy you want, to put it into the Constitution so the legislators would not be able to tinker with it. You got long, detailed, and oftentimes frequently amended constitutions. During the 20th century, a shift in understanding occurred, and this is tied very closely to the development of the model state constitution by the National Municipal League in the 1920s. The move was from a distrust of government to an emphasis on providing power to government so it could effectively govern and serve the interests of the people. The idea was not to constrain the executive, to constrain the legislature, but to streamline government so it could act more effectively. This is the progressive era. This is the era in which you see the same thing happening or being proposed at the federal level. And so what you see happen in Alaska is a move to create a constitution, which is indeed one in which restrictions on the legislature are minimized, a strong executive is created to have a more effective government, a unified court system is created, and the idea, again, to make government more effective to serve the people. Of course, Alaska is not the only Western state that during the mid-20th century adopted a first constitution, because Hawaii and Alaska are so closely linked in their constitutional history and in their campaigns for statehood. Let me compare briefly the drafting and substance of these two constitutions. Both territories authorized conventions following plebiscites that approved efforts to attain statehood. Alaska's plebiscite was in 1946, Hawaii's 6 years later. Both territories elected convention delegates in nonpartisan elections, but the composition of the conventions differed dramatically. Hawaii's delegates were extraordinarily diverse. Of the 63 delegates, 27 were Caucasian, 19 of Japanese ancestry, 12 Native Hawaiian, and 5 of Chinese ancestry. In Alaska, only one delegate Frank Paratovich was Native Alaskan. And the difference in composition of the two conventions affected what the Constitution said. The Hawaii Constitution expressly endorsed the diversity of heritage and culture in the state, and it banned segregation in any state military organization. In contrast, the Alaska Constitution did not address directly the cultural diversity of the state, and a proposal by Delegate Muktuk Marston to include a state land grant to Native Alaskans was defeated in the convention. Yet the presence of a single Native Alaskan delegate was important, as Paratovich succeeded in limiting the literacy requirement in the convention. Initially, the proposal was that to vote, one had to be able to both read and speak the English language, and under his urging, it was changed to read or speak the English language. Both the Hawaii and Alaska constitutions reflected the constitutional vision of the model state constitution. Both are relatively brief documents featuring strong executives, unified court systems, and few non-civil liberties restrictions on state legislatures. Both follow the model state constitution in providing for home rule, although obviously the geographic differences produce different systems of home rule in the two states. Both also promote popular engagement in governing by providing for a periodic vote on whether to have a further constitutional convention, although only Alaska provides for initiative, referendum, and recall. Yeah, whereas the Constitution of Alaska has remained relatively unchanged since its adoption, the Hawaii Constitution has not. The similarities between the constitutions did mean they would both work in different contexts. In 1968, less than a decade after statehood, Hawaii held a constitutional convention to deal with malapportionment of the state legislature. And once the convention was called, the delegates proposed 23 different amendments, of which 22 were ratified. 10 years later, voters approved another convention, which proposed 34 more amendments, all of which were ratified. Thus, Hawaii has averaged more than 2 amendments every year, and Alaska less than 1 every 2 years. I think, given time constraints, I will stop there. I'll let Bob Williams speak, and I hope we'll have some time for some comments and questions. Thank you very much.
Thanks, Alan. After 35 years, I'm still learning from you. Amazing. I also want to thank the organizers for recognizing the importance of your state constitution and state constitutions. Generally, an anniversary, whenever it really is a terrible thing to waste. So it's a good excuse to take a look at the Alaska Constitution, and I want to talk generally about where the Alaska Constitution and state constitutions generally fit within the larger American constitutional tradition. And when we talk about state constitutions in the same room with the United States Constitution, we see a kind of a paradox because, and I don't want to offend anybody, but my guess is most people know more about the United States Constitution than they do about the state constitution or state constitutions generally. I may be wrong about that. But the paradox is that people know more about the U.S. Constitution, but none of us can do anything about it. It's virtually impossible to amend. Most of us will never appear before the United States Supreme Court or even U.S. Courts of Appeals. Some of us certainly will all the time, but so we know about the U.S. Constitution, but we can't have much involvement with it. Rather, state constitutions are low visibility. People really don't know much about their state constitutions, but yet state constitutions are available for our involvement in various ways. Through the state courts, state constitutions are much easier to amend. than the U.S. Constitution. We really could have some involvement with our state constitutions, but in fact, they remain pretty low visibility in our country. I got to tell you, there is a book about the Alaska Constitution. You need to know about this, Gerald McBeath. It's a little old, out of date, but because your Constitution doesn't change that much, but for the court decisions, it's a very important resource for you. And again, this paradox, I think, arises because both the United States Constitution and in our case, the Alaska Constitution, go by the name Constitution. So people think, well, there's a big one and a little one. And the little ones are kind of little versions of the big one. And that's really a bad mistake because the U.S. Constitution and the state constitutions are really very different legally and politically from each other. So I want to go in three parts too. That's the first part. Alaska in the late 1950s, not one of the original states, okay? So Alaskans had to go to Congress with their hat in their hand. Could you let us join the Union? We don't want to offend anybody. Here's our Constitution. It doesn't push the envelope particularly, and please let us get into the Union. The 13 original colonies, states, they didn't have to do that, by gosh. I mean, they created the United States government. So right away, there's a distinction in the initial process of constitutionalizing state government, where the 37 non-original states, and if we ever got another state, would have to bow and scrape in front of Congress and comply with demands of Congress and all sorts of things that the original 13 never had to do. The southern states also had to do it when they came back into the Union after the Civil War. So the United States really came from a colony of England to become a colonial power. So the territories were really, we call them territories, but they're really colonies. And when they came into the Union, they were often reacting just the way we reacted to what we saw oppression from England. Territories, when they began to write their constitutions, reacted from what they saw as oppression from the United States government. Again, different from the original 13. So there's an epic story that each of these states have, pretty unique, each of them. Obviously, you heard from Dr. Tarr how different the Hawaii and Alaska have been. But there's a number of other very important differences between the U.S. Constitution and state constitutions generally. Of course, state constitutions are subnational constitutions. They work within a larger constitution that is dominant. Okay, so the state constitutions, of course, can't come into conflict with the United States Constitution or even with valid federal laws or treaties. Even federal common law can trump a state constitutional provision. So they're constrained by the content of federal constitutional and statutory law, and the non-original 37 were constrained by this process of admission. Very important legally is that, and you know this from civics, U.S. Constitution enumerated various powers for the federal government to exercise. And yes, the Supreme Court has expanded those over the years and everything, but the key question about a federal statute is, where does the Congress get the authority to pass that statute? We do not ask that about state statutes, because at the time of creation of the federal government, these enumerated powers were given to the federal government. Everything else was reserved to the states and to the people. So state legislatures utilize residual plenary power. You don't have to ask where's that state legislature get the power to pass a criminal code, a landlord-tenant act, a corporation statute. That's within the reserved powers of the states. The key question in state constitutional law is, why cannot the legislature pass that statute? What gets in the way? So the key questions, other than rights, that Dean Chemerinsky was talking about, that I'll talk about in a second, but about how the government operates, the key questions at the federal level are enumerations of power and implied powers, okay? Where did the federal government get the power to pass that Affordable Health Care Act? Was it interstate commerce? Turned out no. Power to tax. But where did that power come from? We don't ask that question in state constitutional law. Is there some kind of a limitation on what the state legislature can do, either in the state constitution or sometimes in the U.S. Constitution? States can't impair the obligation of contract. Why? Because the U.S. Constitution says they can't. So that's a difference. State constitutions emanate directly from the people in 49 out of the 50 states. In Delaware, the legislature can change the Constitution over 2 legislative sessions. The other 49, the pedigree of your Constitution here in Alaska and the other 48 comes directly from the citizens of the state. Remember, the U.S. Constitution was never voted on by people of the early United States. We don't vote on amendments, right? They're sent either to the state legislature. There is this possibility of a convention to ratify amendments. But so the pedigree of our state constitutions is much more linked to popular sovereignty, to the power of people. In fact, the state constitutions are a lot more democratic than the federal constitution. Nothing wrong with the federal constitution, I understand, but this is a very big difference, and it yields a very important doctrine of judicial review in state constitutional law that's different from federal constitutional law. Virtually all of the states, I haven't checked Alaska, subscribe to a doctrine that state constitutional provisions should be interpreted according to what the people who voted to ratify them would have thought they meant. Okay, quite fascinating. I get calls about, gee, what should we do in this case? I say, send a summer college student to the library to look at the newspaper editorials at the time that provision was adopted. And lawyers around the country, they go, why would I do that? And I say, look, I bet about 10 minutes I can find a case in your state that says this material is relevant because we want to know what the voting public thought they were voting for. Sometimes it works, sometimes it doesn't. I worked on a North Dakota case. We found exactly what we wanted in the newspaper editorials, and the court ignored it, and we lost. But by gosh, we had the argument. There's nothing like this in federal constitutional interpretation. The voice of the people? There was no voice of the people, and there still isn't today. So very, very important for lawyers in this kind of stuff. State constitutions contain a lot of policy provisions, matters that we would normally think would be dealt with by ordinary statutory law. And there are lots of reasons for this. Louisiana says that Huey P. Long's birthday has to be a state holiday. And by gosh, it has to be. You can make fun of the Constitution. Louisiana Constitution also has a whole chapter on levies. Gee, why would that be important in Louisiana? Why don't we have that in New Jersey? Okay, so these policy, and the average 40% of state constitutions is made up of policy provisions that wouldn't have to be in the Constitution, but they are for various political and historical reasons. Alaska seems to be, when it was studied, seemed to be under that national average, around 22%, so not so bad. Positive rights, Dean Chemerinsky mentioned this. Mandates of government service, no such thing in the U.S. Constitution at all. Education, health and safety, all of these things. State constitutions are much easier to amend, okay? I've said it's virtually impossible to amend the U.S. Constitution. We'll see, but gosh, I don't know what the rate is. It's a very, very low rate, at least after 1791 with the first 10. Consequently, state constitutions are much longer. This is also a consequence of the fact that residual plenary power covers a greater territory of law and politics than enumerated powers do. So they're much longer because they've accreted over the years, and because there's more to deal with, particularly if you're trying to limit government in some ways. And a second consequence, or maybe a third, of this is that a lot of state constitutional provisions are layered. They're the product of 2 or 3 or 4 amendments and changes in thought because of the passage of time and issues that are involved in the society or the economy. But for a couple of federal amendments, we don't have that at all. And of course, the federal amendments are added at the end, not engrossed into the Constitution itself. But if you're looking to in a lawsuit to try to interpret a state constitutional provision, you've got to check. Was this in the original Constitution? Well, no, yes, but it was changed in 1922, and then it was changed again in 1956. It's like a statute in a way, the way we lawyers think of it. Virtually unheard of at federal constitutional law. So very quickly, state constitution, it was thought for a long time that to have a real constitution, something that was really a constitution, it had to really have entrenched, long-term, general, textual stability, difficult to change. Okay, and we thought that because that's the way our United States Constitution is. But recent research, it's in my paper, very interesting, important, couple of very smart young women are taking the position that, no, but that's okay, but you can have a real constitution as well that's specific, not general. It's detailed, and it's frequently modified. They're talking about the state constitutions. Where that can also operate to limit what governmental officials do, but the limits are the product of successive generations. So I was going to talk about the new Judicial Federalism, where state courts can interpret their state constitutions to provide more protective rights than federal constitutional rights, but I could never compete with Dean Chemerinsky. And I think that's something people in Alaska are quite familiar with. He mentioned a number of the provisions in the Constitution. If you sit down and read it, you'll go, I never heard of this. You know, very important. So you have textual provisions that have a different history and a different line of cases or a different jurisprudence. Or in a recent state like Alaska, maybe you're going to participate in developing this jurisprudence of a provision that has no analog in the United States Constitution. Pretty exciting. Pennsylvania Supreme Court just struck down partisan gerrymandering based on a provision that doesn't appear in the U.S. Constitution. All elections must be free and equal. Gosh, what a weird idea, you know. Where'd that come? It's in the Pennsylvania Constitution since 1776, you know, long before the U.S. Constitution was even drafted. Apparently appears in 13 state constitutions. Where are the lawyers? All in federal court. Okay, there are various examples of this. It turns out that Alaska Constitution, as Alan said, not often changed, way below the national average for amendments. And in the 1950s, when it was adopted, it was received with accolades as the best state constitution in the country. Tell that to Alaskan Native folks. They may not agree with that. Over the years, I'm sure other defects have appeared. The Alaska Constitution is obviously much easier to amend than the U.S. Constitution, but it's not as easy as other states that allow the initiative to change the Constitution or what have you. You do have the automatic referendum every 10 years, which is interesting. It's a burden-shifting, Thomas Jefferson's idea a burden-shifting mechanism so that those who want to consider a new constitution or amendments to the Constitution don't have the burden of convincing people to agree to have a vote. There's going to be a vote. But what we've seen, and I'll conclude in a minute, is constitutional conventions are really out of style in the states. Political scientists have called it convention phobia. And what's interesting is back when, in earlier generations, when constitutional conventions were happening with some frequency, it was the politicians and the special interests who were afraid of the people operating through constitutional conventions. Now it's completely turned on its head. The people are afraid of politicians and special interests operating through constitutional conventions. All of the votes have been turned down the last at least generation and maybe more. Add to the mix the new development of dark money. New York had a vote last year, and it was all about what's a constitutional convention going to be like in New York with the advent of dark money. People are going to lose their rights and everything else. So whether you're going to have a constitutional convention or not, you have a great constitution. It's not perfect. There are mechanisms to address this. One of them is the Constitutional Commission that Dr. Tarr mentioned, a modern 120-year-old invention that's been used very effectively by people. The other problem with your automatic vote is you can't have a limited constitutional convention. It's right in your text. And a limited constitutional convention has been used quite effectively in a number of the states. Is it judicially enforceable? Evidence looks pretty clear that it is if the people vote to limit the constitutional convention, not the legislature. So I suggest to you going forward, you can celebrate the anniversary, you can be proud of what you have based on the trial and error experience of all the other states that came before you. But I'm sure it's not perfect, and you're not stuck with it. There are ways to make it better, even without a constitutional convention, and I'm a great believer in the Constitutional Commission. It's cheap, expert advice, and it's safeguarded because their proposals have to go through the legislature. So thanks very much. We hope to try to keep a little time for Q&A, but I don't think we did.
I think we can take one or two questions.
If anybody has.
And I do have a microphone if there are any questions. If not, Professor Metzloff, if you had any comments?
Well, yeah, I was interested in what you're just saying with the sort of limited constitutional conventions. I guess I understand the fear of a new constitutional convention that would come in, firstly for the federal constitution, don't want that to happen. How do you limit it, and what are the kind of typical limitations that would be called?
In New Jersey, for example, we couldn't have, it was 80 years before we could get a constitutional convention, from 1844 till, close to 100 years. Because the Constitution required a senator from each county. The tiniest county had a senator. This is before one person, one vote, of course. The tiniest county had one senator, and the biggest county had one senator. And so the small counties defeated any chance to have a constitutional convention. The liberal Republican governor in 1947 said, well, why don't we take that off the table? And everybody went, yeah, let's do it that way. But so they passed a statute, said, let's have a vote on whether to have a constitutional convention that will be prohibited from addressing apportionment of the Senate. The delegates had to run, so they're elected, they had to run taking an oath of office not to address reapportionment of the Senate. The rules of the Constitutional Convention said you cannot address reapportionment of the Senate. There were 2 or 3 other things that were included in the statute. So the people themselves voted to limit, in this case only only one limit, they're delegates at a constitutional convention. Now, it wasn't tested in the courts, but Alan and I looked at this a few years ago, and there are cases from 3 or 4 states that enforce these kinds of limits in the 1940s and through there, not when they're imposed by the legislature, but when they're voted on by the people to limit their own delegates. So we never have had an example at the federal level. Is it guaranteed? No. And frankly, the people didn't have a choice to vote, let's have a constitutional convention that's not limited. So it's imperfect, but it all depends on how bad you think your Constitution is. I mean, it's a leap of faith to take a shot at making it better because it might be made worse. And that's why I think, you could certainly have a limited constitutional commission, right? Limited to, how about Native Alaskan rights, something like that. But there's no guarantee.
Actually, I don't think the Alaska Constitution allows that. Because basically, if I understand it, it says that no call for a constitutional convention shall limit the powers of the convention.
I understand. That's why I think a commission, which was focused on 2 or 3 problems in the Constitution, that would study the matter, generate.
An amendment,
I'm sorry.
and then you recommend an amendment.
To the legislature.
Okay, so it goes through an amendment process,
Yeah.
not a convention
Yeah,
process.
and no guarantee that the legislature will do what the commission asks. But the commission process raises public awareness, educates the public. Again, no guarantees.
No guarantees, but also the Alaska system, under our case law, there are certain limitations.
Sure.
Basically, the amendment process can only take it so far, because at a certain point, I believe under one of the cases, the Ulmer case, if it is too broad a change, then it has to be brought by convention. So there's certain limitations.
Oh, I need to know that case.
There's a revision.
Yeah.
They came up with a qualitative and a quantitative test, which is
But I didn't
unique
know it
to
was in
Alaska.
Alaska.
Which is unique to Alaska. They took part of the Constitution from California and how they modified it, and they changed it. It's a very interesting test.
You know what some of the states have done too is a 2-step process. This happened in Illinois, Texas, Florida, that the first step is to modify the constitutional amendment process. So one could imagine, it's not easy to amend state constitutions, but one could imagine an amendment to that clause you just read that said, provided, however, that if the people vote for a limit, it will be enforceable. With the legislature, people laugh. You'd be amazed what gets in state constitutions.
Illinois did that.
Absolutely. Illinois, Texas, Florida. Florida amended its constitution that said the legislature could write a new constitution and present it to the people. That's how I got interested. I got a job working for one of those state legislators in '67. But my point here is you're saying we're trapped by we're constrained by our Constitution. Only part way. I mean, it's a matter of, what did we call our piece? Getting from here to there.
Yeah.
I think you should make the state constitution work for you rather than you working for the state constitution. But I don't mean willy-nilly amend it whenever you feel like it, but this is a place where if the experience in the states with limited constitutional conventions appeals to people, you don't have to be trapped by that provision in your Constitution.
Good. All right, so we're taking a break.
Yeah, so let's thank you to our speakers, our first panel.